Hi Dan, it's Rob from the IP department. I hope you don't mind me calling you, only Cynthia from your department was up here yesterday. She mentioned that you're working on a case that sounds very similar to a case I did last year when I was working in commercial. I thought you might find it helpful to talk things through.
Hi Rob, that'd be fantastic. I've only been in the commercial department for 2 weeks. I've just finished my seat in litigation and I'm still getting my head around things over here.
I can imagine. Don't worry, it gets easier. I'm told that you're working on a dispute that's come up within a limited company. Is that right?
Yeah, that's right. It's a company called Luxury Land Limited and it was registered at Companies House in 2010. There were 4 subscribers who all decided to be directors and shareholders with equal shareholdings. This hasn't changed, although there are now 5 employees as well.
Are these employers shareholders?
No, apparently the directors considered issuing shares to 2 of them, but then this dispute arose. That idea has been put on hold for the foreseeable future.
I see. And as I understand it from what Cynthia said, this company buys up land, obtains planning permission to build on the land, and then sells it on to property developers and investors.
Yes, that's right, and they've done fantastically well up until now.
So what happened?
Well, all of the directors have different responsibilities. One of them, Neil Hughes, is responsible for finding land that the company can buy. So, as part of his role, in 2016, he negotiated an agreement to purchase a piece of land from a landowner called Bethany Ewers. But it turns out that this landowner, Ms Ewers, knew Mr Hughes personally.
In what capacity?
They're members of the same parents' association at their children's school and they're both quite political as well. They're very active members of their local Conservative Party. In fact, they've both attended the annual party conference for the last 2 years. Once at Brighton and once in Manchester, which meant leaving their families behind in London for 5 nights. Apparently there are even photos of them together on the party's local website, drinking champagne. Just the 2 of them.
Ah, I see the beginning of the problem. Go on.
Mr Hughes told the other directors about the availability of the land and they expressed an interest in buying it. Between July 2013 and February 2014, Mr Hughes incurred significant costs on behalf of the company in seeking planning permission to build on the land. This was eventually granted by the local authority, but it transpires that the public register for the application lists Neil Hughes as the named applicant. In other words, he purchased the land in his sole name and not the name of the company.
I imagine the other directors are far from happy.
That's right. They've approached me to see what their options are. Ultimately, they want him out and want to know if it's possible.
It usually comes down to what's in the company's Articles of Association. If they've adopted model articles, then Article 18 sets out certain circumstances where a person ceases to be a director, but none of these circumstances are applicable here. However, it does say in this article that a director will cease to be a director by virtue of any provisions of the Companies Act 2006 which prohibits him or her from being a director.
So we need to look at the Act then?
We do. And I can tell you that under the Act, a director can be removed from office by the passing of an ordinary resolution at a general meeting.
I see.
Be careful though, he'll have rights under employment legislation and he's got shares. Remember, shareholders can't force any other shareholder to sell his shares unless express rights are reserved in the articles or in a shareholders' agreement.
Oh, it's just as complicated as I thought. What do you suggest I do then?
Well, it is clear that Mr Hughes has breached the duty placed on company directors to act in the best interests of the company at all times. Under Section 177 of the Companies Act, they have a duty to avoid situations in which they can't make a fair decision because they'll be personally affected by the result. If a situation like this comes up, where their loyalties may be divided, they have to say so.
Oh, I see. So, based on this breach, our clients, as the other directors, can apply to the court for an injunction to prevent the sale of the land if it hasn't gone through yet.
Exactly. And even if the sale has already gone through, you can still take steps to protect our clients.
issue proceedings in the High Court?
Yes, take action in the name of the company, claiming that the director, on the grounds of his breach, should be forced to account to the company for all and any future profit made through the sale of the land, including any future proceeds from the sale.
OK, I'm writing this down.
In addition, you can ask that he indemnify the company for any taxes to be incurred, for example, in this case, capital gains tax.
This all sounds very positive. I'm sure my clients will be reassured by this. I don't suppose you still have a copy of all the paperwork, do you?
I don't, unfortunately. Just a copy of what was handed down and the final court order setting out what payments were due and when, etc. The rest went to the storage facility, so you'd have to send out a search party, I'm afraid.
No, that's brilliant. Thank you so much. I owe you one.
No problem at all. Let me know if you need anything else. I miss it over there.